Looks like our numbers have slowed, so I guess we can go ahead and get started. Thank you so much. Welcome, everyone, and thank you for joining us today for our webinar entitled Extreme Risk Protection Orders and Implementation Introspection. Our conversation today is co-sponsored with the Johns Hopkins Center for Gun Violence Solutions, and we appreciate their collaboration in putting this event together. Before we begin, just a few housekeeping items. Our format for today will be a brief introduction, followed by a presentation from our panelists. We'll then follow that with a discussion to include questions from our audience. At the bottom of your screen, you will see an option for Q&A. Please drop your questions here at any point throughout the presentation. We'll certainly try to get to as many of those questions as we're able to. Unfortunately, because of the limited amount of time we have together today, we may not be able to get to all of them. If for any reason your question is not answered, please feel free to reach out to myself or our panelists after this event. We will be providing their contact information in the shared chat. The session is also being recorded and will be available afterwards on the Rockefeller Institute of Government website. We will provide a notification of its release to the email address you signed up with. Now for our event. Extreme risk protection orders, also known as red flag laws, are a newer approach to combating gun violence that are already showing promise in achieving this end. We are very excited to welcome our panelists, Lisa Geller and Spencer Cantrell, to join us to share their experiences and insights about extreme risk protection orders. Lisa is a senior advisor for implementation, and Spencer is an assistant scientist, both at the Johns Hopkins Center for Gun Violence Solutions. Together, they also lead the Johns Hopkins National ERPO Resource Center. Thank you both so much for joining us today.
Thank you, Jackie. Thanks so much for having us. Thanks to Rockefeller Institute. We are excited to talk about some of the lessons that we've learned in our 2.5-ish years, right, Spencer, running the National ERPO Resource Center. I should note we're doing this in our capacity as researchers and attorneys at Johns Hopkins at the Center for Gun Violence Solutions, but a lot of the information we're going to share as I share my screen is going to be informed by our work on the ground in many of the jurisdictions that have extreme risk protection order laws. So with that, I can only see Spencer. So in a second, once my screen loads, tell me if you can see it. And there, we're good. So thank you again for tuning into this webinar about ERPO, about implementation. I want to just start off with the scope of the problem of gun violence. And we just released a couple weeks ago at the end of June, a new report examining the most recent data from the CDC on gun violence, and that's data from 2023. So I wanted to make sure I started off for those who are newer to this area. I assume a lot of folks tuning in know a lot about gun violence, know a lot about ERPO, but I just want to start with what this epidemic looks like in the US. In 2023, there were almost 47,000 gun deaths. And the vast majority of those, or the majority of those, were gun suicides. In fact, gun suicides reached an all-time high when we look at the 2023 data. So even though we are hearing in 2024 and into 2025 that gun homicides are going down, gun suicides are going up, and that's certainly represented in the data that we've seen in 2023. So there's a lot more in this report. This report actually focused on gun suicide. So you can look, if you're working at the state level, you can go into this report and see what the state data looks like in your state, as well as solutions to this problem that we take the public health approach to solutions at our center. So we have policy priorities, including ERPOs, for addressing gun violence. And you can scan the QR code and we'll make sure that you get a copy of the slides if you're interested. And I know Jackie said this is being recorded, so you can if you aren't able to get your phone out now, you can certainly go back and scan this to read the report later. Now, the reason I start with this is because gun violence looks like a lot of different things. It's not just mass shootings. Mass shootings represent a small percentage of gun deaths in this country, though they do make the news more than other forms of gun violence, certainly more than gun suicides, which rarely make the news unless they're coupled with another shooting, a mass shooting, or another homicide. So I want folks to be aware of what gun violence looks like, what it doesn't look like, and also keeping this in mind when we're talking about how extreme risk protection orders can be used, because they are a policy that we've seen being used to address various forms of gun violence, gun suicides, mass shootings, domestic violence, political violence, and various other forms of gun violence. So Today, Spencer and I are going to give a brief overview of extreme risk protection orders because I think some folks on this call are very well versed in this topic area, but we want to give enough so that if you are new to this area, you understand what we're talking about. We're going to do a state highlight, just looking briefly at New York's extreme risk protection order law, how it's similar to other extreme risk protection order laws, how it may be different. And then we want to dive into lessons from the field, opportunities for implementation, case studies, and data on extreme risk protection orders, how they've been used. So we will just get right in and talk briefly about extreme risk protection orders. After the Sandy Hook shooting in 2012, there was a renewed interest in talking about the intersection or lack thereof between mental illness and gun violence. And when I first started working on gun violence prevention in 2015, most of the conversation still at that point was talking about how mental illness is the cause of gun violence. If we can disarm individuals living with mental illness, we can solve our gun violence problem. That is not true. It was not true then. It is not true now. In fact, mental illness alone contributes very little to violence and very little to gun violence. And so instead, we want to take an approach where we're focusing on behaviors, individuals exhibiting dangerous behaviors, risky behaviors, and intervening there as opposed to stigmatizing individuals living with mental illness, most of which will not become violent and in fact are more likely to be victims of violence. So at the time after the Sandy Hook shooting, there were two states with a risk warrant type law, with an ERPO style law, and that's Connecticut and Indiana. And they passed their extreme risk protection orders in 1999 in Connecticut and 2005 in Indiana as a way to intervene before someone does something, but at the same time, they were passed in response to shootings that had occurred in their community. So there's the Connecticut lottery shooting that spurred the Connecticut ERPO law. And then there was a shooting of a law enforcement officer, Jake Laird, in Indiana that spurred their passage. So after the Sandy Hook shooting, our boss, our executive director, now our co-director of our center, Josh Horowitz, was a part of a group that convened folks to talk about the extreme risk protection order policy, a way that you could give judges and give law enforcement clear legal authority to remove firearms before something happened, but when you knew they were at risk of committing harm, because the conversation at the time was that law enforcement didn't have a way to legally intervene. Someone hadn't done something yet, and so you couldn't go and remove their firearms, prohibit them from purchasing firearms. So the goal of ERPO is to allow judges that clear legal authority and law enforcement to have that clear legal authority to use a civil order and temporarily restrict someone's access to firearms. These laws are relatively new, but they are built off of domestic violence protection orders, which have existed for decades in the US. So those are also civil protection orders. They also are, hopefully somewhat preventative in nature, though, somewhat reactive in the sense that you're responding to a domestic violence incident. The ways in which they are different, though, is that extreme risk protection orders can be petitioned by groups other than survivors of domestic violence, victims of domestic violence, and always include law enforcement. So all of the jurisdictions, 21 states, the District of Columbia, and the U.S. Virgin Islands allow law enforcement to petition. Most states have gone beyond law enforcement, allowing family members, household members, healthcare providers, and some other groups to petition. Just like DVPOs, domestic violence protection orders, there is an ex parte or temporary order that usually lasts up to 2 weeks. Again, these are going to vary by state. So we're going to talk briefly about New York's law so you can get kind of a sense of what that law looks like, since a lot of folks on this call, I think, are calling in from New York. And then there's a final order that typically lasts up to a year. A couple states, California, and most recently, as of a couple weeks ago, Delaware extended their final order to last up to 5 years. So that does not mean automatically 5 years, but up to 5 years. But most states last up to a year. A couple states are a little less than that, and a couple states are a little more than that. So this is the list of jurisdictions, states, and territories that have extreme risk protection order laws. California's passed in 2014, went into effect in 2016, and we've really seen the majority of states adopt these laws since then. Most recently, the U.S. Virgin Islands in January of 2024, and we've seen a couple states that were in 2024, and a lot of them were after the Parkland shooting in 2018. So before I hand it over to Spencer, I just want to show a quick Venn diagram of the ways in which we see extreme risk protection orders being used. I kind of alluded to this at the beginning, that we see them being used in a variety of ways. Threats to self, so an individual threatening or experiencing suicidality, and threats to others. But we see a lot when we look at the petitions, and there's a lot of research out there, and we're going to get to that towards the end of this presentation, showing that ERPOs are used quite often in response to threats to self and others. So we want to, if you take something away from how ERPOs can be used, we really want to focus on behaviors, not diagnoses alone. And Spencer's going to talk about some of the factors that we see ERPOs considered for.
Thanks, Lisa. And before I get into the factors to consider, just a reminder that we do have the Q&A open here in the chat section of the webinar. So just to reiterate, if you have questions that you would like answered at the end of the webinar and don't want to forget them, feel free to go ahead and type those there, and we'll be sure to get to them at the end. So every state's ERPO law is going to be a little bit different, right? Every state statutes vary and fit within their statutory scheme. But these are, broadly speaking, the factors that are used in ERPOs, with some variation, like we said. So the first and foremost factor is whether someone is making threats of violence or acting violently towards themselves or others. So if someone is threatening suicidal or homicidal behavior, then that in and of itself could be grounds for an ERPO. The other criteria listed here are often something that you would look at in totality of the circumstances, but these are evidence-based risk factors that have been identified to use when determining whether or not an ERPO is appropriate. I will note that the factors at the bottom, alcohol or substance abuse or recent acquisition of weapons, those in and of themselves are not going to be grounds for an ERPO, right? We wouldn't want to see someone going out to purchase a gun being a respondent in an ERPO case, or someone who has substance abuse issues. That alone is not grounds for an ERPO, right? But when you combine patterns of violent acts, a history of violence, brandishing of firearms with alcohol or substance abuse or brandishing of firearms, then we might be getting to criteria where an ERPO is appropriate, right? So that's the factors. On ERPO.org, we do have every state's ERPO factors listed out on our website by state. So that's something you can look at. I also just wanted to quickly go over the ERPO process, just the broad strokes. So this is oversimplified. Hopefully you don't look at this and feel like you're ready to go to court. But someone is going to file the petition for the ERPO case. And this is, every state has their own form, their own forms or affidavits, petitions that you can fill out to state why there should be an ERPO in a case, and what are the risk factors that have been identified, and information about the respondent and their firearms. That form is filed with the courts. In some states, it's only done during business hours. In some states, there's a way to do it 24/7. And so that's something that a judicial officer, either overnight or the next day, will decide whether or not there are grounds to grant the temporary order. We say judicial officer because sometimes it's a commissioner, a magistrate, a judge, just depending on what judicial officers are called in your state. Once that order, the temporary order is if it's granted, then that order is served on the respondent, which means that the respondent gets a copy of the paperwork saying that they are subject to a temporary ERPO, telling them how and when they have to relinquish their firearms, and telling them when a final ERPO hearing will be held. And then there would be a final ERPO hearing scheduled, usually within 1 to 2 weeks. And then at that final ERPO hearing, the respondent is there, the petitioner is there. Everyone has the right to present evidence, to cross-examine witnesses, to tell their side of the story. Full due process, obviously, is included in these cases. And then at that final ERPO hearing, a judicial officer determines whether or not there are grounds to grant or deny that final ERPO for the duration of the order, which, depending on your state statute, is 6 months, 1 year, 2 years, 5 years, just depending on the statute. So looking at New York, we're looking at New York, given how we're working with the Rockefeller Institute. But like I said on ERPO.org, we have every state statute broken down. But this just kind of gives you a taste for what it looks like around the country. But the ex parte orders in New York are valid for up to 6 days. The final orders are valid for up to 1 year. And then the burden of proof is also listed here. In the next slide, we have a little bit more information about New York's ERPO law, the factors to consider. So before I'd shown you kind of our model list of ERPO factors, this is the New York State statutes, ERPO factors to consider. So this would be threats of or acts of violence toward self or others, violations of domestic violence protection orders or ERPOs, pending convictions for offenses involving weapons, reckless use or display of firearms, substance and or alcohol abuse, and then the recent acquisition of firearms. So that's just a little bit of the New York. And then in New York, this is the list of petitioners. So like Lisa said, law enforcement can petition in every state within ERPO law. Many states also have family members or household members that can petition. Family and household members are defined a little bit differently in every state's statutes. School administrators are pretty unique to New York, and then healthcare practitioners are eligible petitioners in 6 states plus the District of Columbia. So looking at ERPOs versus domestic violence protection orders. So Lisa said ERPOs were modeled off of domestic violence protection orders. They're very similar in a lot of ways. They're both civil orders that follow due process protections that are time limited, ordered by a judicial officer. In domestic violence protection orders, the only eligible petitioner is the victim or survivor of that abuse. In an ERPO case, the list of petitioners is much broader. So it can include the family or household members, like I mentioned, and it can also include law enforcement. The relief in the domestic violence protection order is much more robust. So when I practiced with domestic violence survivors, representing them in court in Maryland, there was a lot of holistic relief that we could ask for in a protection order to help a survivor feel and be safe, right? So looking at stay away orders, no contact orders, temporary child custody orders, use or possession of a residence or a car, and also firearm removal and domestic violence protection orders. In ERPO cases, the sole relief is removing firearms. And so I would just want to say that the relief offered in an ERPOs is very narrow, and I would never want to see a domestic violence survivor filing for an ERPO when what they really need or want is a domestic violence protection order. And since ERPOs are newer, that's just something that we always make sure to remark on. Now, with that being said, I will also note that with ERPOs, we are in some states and cities seeing more robust firearm removal processes in ERPOs than we are in domestic violence protection orders, even though firearm relinquishment is required under both in certain circumstances. And so it's also just a word of caution and something that Lisa and I are trying to look into more going forward, ensuring that firearms are being removed equitably in ERPOs and DVPOs, and not wanting to strain court systems by having survivors go back to court multiple times, not wanting to strain victims or survivors or victim services by having them go back to court, but also making sure that victims and survivors of domestic violence are safe. And so I think that there are some questions in here about in the chat and the Q&A. I just want to note that there's a question about involuntary commitment versus ERPOs. And I will say that something Lisa and I have heard around the country quite a bit is that some people will be held on 72-hour holds. That's often not enough to qualify for the firearm removal under federal law. And many times when someone is being threatened with involuntary commitment, can say that they will agree to the commitment, and then it's a voluntary commitment, and then there is still not a firearm prohibition. And so happy to chat offline about some of the differences in individual states in your involuntary commitment versus your ERPO law, because that's really getting into the weeds.
And
Lisa, back.
thank you. No, that's great. And we will definitely more thoroughly answer those questions at the end. I would also just say for the individual who wrote about the 5150 to look at the Bullet Points Project website, especially because they're based out of California. You can read a little more there about why a 5150 might be appropriate for some individuals threatening, to harm self or others, but why an ERPO is also going to fill a gap for individuals who don't meet the 5150 criteria, and also about how the 5150 might not be firearm prohibitory in certain circumstances, and why you, again, might want to potentially do both. In fact, I'm part of a research project interviewing respondents in California to ERPOs, and our papers haven't come out yet, but there are a number of individuals who are getting 5150 and ERPO'd, and on our website, ERPO.org, and on the Hopkins website, we talk about the differences between ERPOs, DVPOs, involuntary commitments, and some other state level laws. So please reach out about that. Check out the Bullet Points Project, and we're happy to answer more about that at the end if that didn't sufficiently answer that question. So thank you, Spencer. Okay, so we want to spend the majority of the rest of our time before we do open for some Q&A and take the rest of these questions at the end, talking about some of the lessons that we've learned in the number of years we've been doing implementation around the country, most specifically with our training and technical assistance grant from the Department of Justice, but even prior to that, working in states as they passed their laws and then subsequently went to implementing them. So some of our takeaways here, this is by no means an exhaustive list, and we have another slide. Spencer and I are each going to give a slide about some opportunities we see for improving implementation. These are just some models that we see being successful around the country. So jurisdictions with robust implementation teams, what I mean by that is jurisdictions either at the state level, or most often we see this at the local level, individuals who know what the law is, when it should be used, when it's not going to be the most appropriate tool, and also how to use it. And that'll get into some of our other opportunities in terms of training and things like that. Hearts and minds being changed over time. We have seen, and the news has reported on time and time again, individuals who were initially opposed to an extreme risk protection order for various reasons, most likely due process critiques, or potentially Second Amendment challenges, both of which are really a non-issue in our opinion. Courts have continuously upheld this law, and then most recently the Supreme Court in the US v. Rahimi made a similar upholding of the domestic violence law, which again, you can make analogies to the DVPO, to the ERPO, as they are very similar in terms of structure and some protection. So hearts and minds being changed over time. We've met with folks on the ground who said, I didn't think this was constitutional. I didn't see there being a need for this in our community, but then someone was threatening me or my community or law enforcement, and I realized that this could be a tool to address violence. That is by no means a unique story. I think Spencer and I have heard that pretty much every time we go somewhere to any of the jurisdictions with ERPO laws, there's someone in the community, whether it's law enforcement or prosecutors or victim advocates, who have that sort of mindset change. Does not mean that everyone is going to have their hearts and minds being changed over time, but I do think it's one of the tools in which you have to see its use potentially by encountering a situation in which you have no other tools to address it besides an extreme risk protection order. And that really goes into why a lot of states have adopted these laws in the first place. Going back to the Parkland shooting, there are many records in the autopsy after that shooting showing that law enforcement knew that individual was a threat to the community, but they didn't have, again, that clear legal authority to intervene. And so we see hearts and minds being changed in that regard. Maybe they didn't have the means before it, or maybe there are no other means to intervene besides an extreme risk protection order. Interdisciplinary leadership goes along with these robust implementation teams. Some of the practices we've seen work the best is not just when law enforcement is tasked with extremist protection orders, or not just when the judiciary is tasked with being trained, or not just when service providers, social service providers are tasked with counseling about these types of extremist protection orders, but rather where there is interdisciplinary leadership, usually in law enforcement, that will stem from the top. The chief of police, the sheriff getting on board with this is going to trickle down into the leadership underneath them using it. So where we see those interdisciplinary meetings as well, where the judiciary is coming together with law enforcement, when they're coming together with prosecutors, really all the entities on the ground that we deem the front lines of implementation, making sure that they're working together is critical, just as it is critical for them to be trained. So I'll just skip to the training. We have found consistently in the jurisdictions that we visit that there is opportunity for increased training. There might be some training at roll call for law enforcement. There might be some annual, 15-minute primer on extremist protection orders for the judiciary. But in jurisdictions that are not handling these quite frequently, it is possible that more frequent, more robust training is going to be needed. Now, we've talked to judges and judicial officers that don't handle these often, that they're having to do a refresher every time an ERPO comes across the bench. And that's fine, because we're not here to prescribe a number of ERPOs that is the right number for any community. There might be overuse in some places if you use 10 ERPOs, but in another county that might be severely underused. We never prescribe a right number of ERPOs. I will say that if a jurisdiction is not using any ERPOs, that might be underused, because we know that there is gun violence in every community, be it homicides, suicides, other forms of homicides like domestic violence, mass shootings, where there is an opportunity. The creation of ERPO liaison coordinators, we have seen, we're going to talk a little bit about federal funding that's available to states, but we have seen some states use either state funding or federal funding to assign an ERPO coordinator, an ERPO attorney, an ERPO liaison, who becomes that state or that jurisdiction's de facto expert on this area, and then is going to really be tasked with making sure that the ERPO programs are working as intended and working well. We can talk a lot more about each one of these. I just want to make sure, because we're at 2:28, that we have time for some of our opportunities for improvement. Services for respondents. This comes up time and time again, that you remove a firearm, but someone could still be suicidal. You remove a firearm, someone could still be perpetrating domestic violence. That is true. A lot of states do not require, most states do not require services for respondents. I do think that there is an opportunity in a lot of jurisdictions to not just remove a firearm, but that can't necessarily be a critique of the ERPO program, because the ERPO is designed to remove a firearm, put that time and space between an individual and their firearm. But that does not mean that there's not an opportunity to pair that with services for respondents, whether it's mental health counseling, whether it's some sort of DV intervention. So I think that we should look into more services for respondents to make sure that the needs, the precipitating event is really being met. And we do see some jurisdictions doing a great job. We visited a jurisdiction where the individual was threatening harm stemming from financial concerns, and one of the concerns being that he couldn't feed his dog. That's a very small part of the contributing factors that contributed to his ERPO, but the law enforcement officers were able to get him food for his dog. That is not written into the statute, that they have to get food for a respondent's dog if that's the reason for why, one of the reasons why they're getting an ERPO, stemming from his economic hardships. But they were using this in a more holistic way to address the underlying and the root causes of violence that led to the threats and led to the crisis that respondent was experiencing. And then burn skip funding. Every state is able to take advantage of the federal funding through the Bipartisan Safer Communities Act. That was allocated for 5 years of funding. That is what funds the TTA Center that Spencer and I co-lead. And so I encourage you, if you work in a state on this issue, that you look into whether or not your state is using the federal funding and how they're using it. It can be used in the states that don't have ERPOs for other crisis intervention orders, and in the jurisdictions that do have ERPOs, it can be used for ERPO. So some more takeaways that we're going to get to. This is a map of most of the places. I don't think all of the places, because we've done quite a bit of travel over the last couple of years, but I think most of the places we visited to work on extreme risk protection order training and technical assistance, including some specific site visits to jurisdictions. At the top on the right, we did a site visit to Lake County, Illinois. The middle photo is from King County, Washington, and then the bottom photo is a statewide visit that we did to the state of Connecticut. Some of the opportunities that we've identified in these visits include better understanding how and if ERPOs can be used to deflect individuals from the criminal legal system. ERPOs are a civil tool, and so the intended purpose is not to criminalize someone's behavior, it's to use a civil tool. However, we recognize that in some of these cases, if an ERPO is violated, there can be criminal charges. However, we are interested and research should explore if an ERPO is being used to deflect someone from the criminal system instead of criminal charges, if they are using an ERPO for civil to deflect them from the criminal system into the civil system. There is always an opportunity for more uniform implementation across jurisdictions. We've visited a lot of places where one county might be leading the way with 25–30% of the ERPOs in that state. And that doesn't mean their neighboring county doesn't have any gun violence or any need for an ERPO. It's probably a lack of awareness, training, potentially funding. And so more uniform implementation across those states, within states, is great. Same with services for respondents. We talked about how some places are doing a really good job connecting services, connecting respondents, but some are not doing this at all. And so maybe an opportunity to explore whether services can be provided for some respondents in some situations. Judicial training, we've done some judicial trainings over the last couple of years, and I find them to be a really great way to get right in front of the judge who's ultimately going to be deciding, are they going to grant the order? Are they going to deny the order? And making sure they know when an ERPO is appropriate. And so if you, again, work in a state that has a judicial training entity, which should be every single state, I encourage you to figure out if they have routine training on ERPOs, how you can, get in the door to some of those trainings and talk about ERPOs, but also any of the other policies that you all may be working on. I'm going to turn it over to Spencer in a second, but improved use of technology and communication to streamline services. We did a site visit last year where this jurisdiction was rolling out a new technology that would essentially not require a judge to be up all night 24 hours or be available 24 hours to decide an ERPO after hours, but instead a technology that would ping them, and they could, without having to go anywhere right from their home, they could review the ex parte order, decide whether or not to grant it or not. And then data collection, I do some research, and I know there's some research colleagues on the call. We always need better access to data to inform whether or not this is working. So I'm gonna turn it over to Spencer. I took way too long, and I apologize for that.
You are great, Lisa. It's all great information. So some other opportunities we have seen in improving implementation of ERPOs is just providing additional legal clarity about the interplay between ERPOs and other firearm removal laws, whether that's domestic violence protection orders, Illinois' clear and present danger, Virginia's safe surrender law. There are often other laws around firearm removal that are important to consider when looking at ERPOs, and then also making sure everyone understands ERPO and how the rules of evidence and civil procedure apply or don't apply in those cases. There's also often questions about ERPO with minor respondents. Lisa and I and some colleagues wrote something last year about ERPO and minor respondents in health affairs in Washington states and Michigan's laws are really clear about ERPOs and minors, but other state statutes have some ambiguities. And so I think clarifying those is an opportunity we've seen. There is sometimes resistance to firearm relinquishment. There are sometimes attitudes by law enforcement or respondents that need to be overcome in ERPO implementation. Like I mentioned earlier, we're sometimes seeing domestic violence firearm removal not receiving the same level of attention. And I think that's a real opportunity to ensure that there's parity in how firearm relinquishment laws operate. And then we have had the opportunity to work with some really lovely folks from the FBI's Criminal Justice Information Services section who are really dutiful in processing ERPOs and making sure that the information goes into NICS and NCIC's database properly and that ERPOs are being recorded properly. I don't know. I think states are sharing this information with CJIS. But I think it can be a little bit wonky to make sure that everyone's doing it properly, given how many folks are involved in that. And so, just, that's an opportunity that we're seeing to make sure that implementers are using those databases properly. Lisa, you already spoke a little bit about the funding opportunities, so I'm going to pass it back to you to talk about data collection and ERPA research.
Okay, great. Thank you. So to date, this is probably a conservative estimate because we don't have real-time data for all the states, but to date, there's been over 75,000 ERPOs filed across the country. And again, what we're seeing is that they've been used in response to threats of suicide and interpersonal violence, including mass shootings. And so I'm going to skip for the interest of time, but you can get a copy of these slides if you wish to review them. Some of the case studies from the research, and I'm just going to put up this slide that summarizes some of, by no means all of the data and research that we have on ERPOs and some of the big themes that come up in the data. If you're interested in more research, we do keep a research document about most of the studies that have been written on extremist protection orders. We are lucky now to have a lot of them. And again, this is just scratching the surface, but we see ERPOs most frequently used for cases of suicide, suicidal ideation. We have the best data showing the impact on ERPO as a suicide prevention tool. Saw a question about this in the chat, so I'm just going to answer it now. Nationwide, what percentage of ERPOs are filed by non-law enforcement petitioners? Most ERPOs are filed by law enforcement, even in the states that have expanded petitioning power to non-law enforcement entities. So there are a few exceptions to that. In Maryland, it's a little closer to 50-50 of law enforcement versus non-law enforcement. But for the most part, even in a state like California, where there are a number of other people who can petition, we're mostly seeing law enforcement. But when we talk to law enforcement, and also when we look at the petitions, a lot of those initial contacts were made by concerned family or friends to law enforcement and law enforcement's filing. ERPOs may play a role in preventing mass shootings. There's a couple of studies looking at mass shootings as ERPO petitions. Most respondents to ERPOs are males, and there's significant county level variation in use. We talked again about that, how some counties might be using it and the neighboring county might not be using it at all. There are just a couple of states where there's been an ERPO in every county. A 2024 study by Jeff Swanson and colleagues found that for every 17 to 23 ERPOs, one suicide was prevented, and they looked at 4 ERPO states there. And again, that just came out at the end of last year. And then there's some studies, and again, there's more findings that I could report on, but increased awareness of ERPO among those who are most likely to encounter people in crisis. So law enforcement and judges and clinicians is needed, increased awareness and increased training.
So, in order for ERPO to be successful, there are some really key implementers on the ground that we've talked about, like law enforcement, judges, the people that provide the follow-up services. But it's also important to have infrastructure in place so that these folks can do their jobs effectively, right? And a lot of the infrastructure at the state and local level really focuses on a few key things. Coordination is absolutely critical. So having coordination, having someone whose job is to help ensure coordination or having a coordinating body is really, really important to help ensure that everyone across the state is using ERPO consistently, consistent forms, consistent application, making sure that that jurisdictions are able to use helpful tools from one jurisdiction to another. Having statewide ERPO training curriculums are great. So that folks across the state are getting the same information, and that can also help facilitate interjurisdictional within the same state enforcement of ERPOs. I also think that increased awareness of ERPO laws is important, especially focused on those individuals that you're going to call upon if someone you know is in crisis. I think it's going to be very hard to have general population awareness as a primary goal at this point in time, given how new ERPO is. But if you think about who do you call when someone you know is in crisis and making sure that those individuals are all trained on ERPOs, so behavioral health providers, law enforcement, 988 crisis operators, making sure that those folks all know about the ERPO law and how it works is really critical. On the next slide, we just have a few local infrastructure um, things that are really similar to what are being highlighted at a state level, right? So designating people to be responsible for firearm relinquishment in law enforcement agencies, making sure you know who those point people are in your ERPO systems, creating a local ERPO working group. In domestic violence context, we often have a domestic violence coordinating council or a DVCC. Having something akin to that in an ERPO context is really valuable, where you bring together all of those local, at a city level or county level, ERPO actors to coordinate. Where it's feasible, having a dedicated ERPO judge is great. And then having a local ERPO advocate to help support ERPO respondents and petitioners is really valuable. On the next slide, we just have a couple of examples of data collection. It's important to collect data standardized across jurisdictions. And some jurisdictions are really good about making this data transparent. I know on this slide, it shows some of the data that's publicly available from Fairfax, Virginia, and across New York State. And having that data is really important, not just to researchers, but to the public, so they can understand how ERPO is being used in their jurisdiction. And that transparency is really key. I think we just wanted to wrap up with a tiny bit more information. If you have questions for us on ERPO implementation or contacting us, this is some background reading from the Consortium for Risk-Based Firearm Policy about how and why ERPOs were developed. This is a really helpful report that we wrote with our colleagues at Everytown on promising approaches for implementing extreme risk laws. It goes into a lot more detail, describing what we just went over with the state and local ERPO infrastructure. And then ERPO.org, we've already mentioned this many times. This is our website, which has a lot of really helpful information, just ERPO.org, state-by-state ERPO information for different implementers, as well as a training or technical assistance request form that you can click on there. And then I think we just have our contact information here at the end. And Lisa and I are both available for questions. Jackie?
Yes, I am back. Thank you so much, Spencer. And just as a quick note, we will be posting the email addresses for both Spencer and Lisa here in the chat momentarily. So if you did not get those, they will be available to you shortly, and we will be sending out the slides after the presentation. We got a lot of great questions, and certainly please feel free to continue to drop those in if anything arises. Start off with one. In terms of thinking about the use of ERPOs, we know obviously it's a prevention related tool. Amelia was wondering, could you talk a little bit about the role of crisis planning? How does that sort of fit into this picture?
You want to go, Spencer? You start.
Sure. So I think that ERPO is one of many tools on the table when you're thinking about crisis planning. And so, when you're thinking about ERPO, it's on a spectrum of interventions along with safe storage or other options, especially in a suicide prevention context. And so I think that it is one tool among many. When someone is threatening to hurt others, ERPO is also used as part of a strategy. Lisa and I have been working a lot more with folks engaged in behavioral threat assessment management who use ERPO as one tool in that crisis management, along with monitoring and making sure that they're engaging in other ways to mitigate those threats. And so ERPO is just one tool in the toolbox among many.
Thank you for that, Spencer. Wendy asked, and this is probably a question many people have, in terms of thinking about the number of gun surrenders, and I know, Lisa, you mentioned that data is, sparse and obviously differs state by state, but do you have any idea about the percentage of compliance for gun surrenders under ERPO and how that may compare to domestic violence orders that include for firearm surrenders?
Yeah, this is a big issue, to be honest. Like in some jurisdictions, there is more compliance requirements than others. Some states have compliance dockets on their court calendars for bringing back respondents to make sure that they complied with the order, that they relinquished firearms. And also, part of the order, you don't have to have firearms. You can be a non-gun owner who's then prohibited for the time that the order's in effect. So I would say this is a big issue because sometimes people may relinquish some of their firearms and not all of them. That being said, I can't think off the top of my head an instance where an ERPO respondent has then gone on to commit the act that they were threatening. I'm sure this has happened before, but that's all to say that I think some people are certainly complying with the order. There's always room for improvement. And I think in the DV context, what Spencer and I have noticed from some of our work in Maryland on relinquishment, like she said it at the beginning, that there is much more robust enforcement in an ERPO than in a DVPO, which is not how it should be. There should be just as much impetus to make sure that a respondent to a DVPO has relinquished all their firearms as there are in an ERPO context. Part of one of the suspicions we have why this may be is that there are so many more DVPOs than there are ERPOs. Most ERPOs are not doing these by the thousands the way maybe Florida is and New York is. A lot of states, we've talked to the judiciary, they're not overwhelmed on their ERPO docket in the way that they might be on their DVPO docket. So always room for improvement on ensuring compliance. We recommend that there be compliance hearings for ERPOs to ensure that the respondent complied with the order, also making it really clear in implementation where you surrender your firearms to, how long you have to do that, that you will face criminal charges if you have not surrendered all your firearms, that you cannot, in some instances, live in a home with firearms, all these sorts of issues that make this quite complex. Spencer, I'm sure I missed something, so please add in there.
Go ahead, Spencer. Sorry.
I'm going to just say you covered it, Lisa. So next question, Jackie. Let's keep it going.
Okay, yes, lots of great questions still coming in. We actually have a guest here who's noted that in 2022, an Associated Press story found that ERPO laws were not being used as often in many of the states that had adopted them. Have you noticed any changes in the use of ERPOs in recent years? And also, have you seen adoption of ERPO laws sort of stagnate and views of them increasingly divide across partisan lines? Is there anything that you can attribute that to? Sort of what's the landscape and how does it look? And I just froze.
So I think we can answer that. The U.S. Virgin Islands most recently passed their ERPO law. Before that, it was Michigan and Minnesota that passed theirs. Maine has their ERPO law on the ballot this November to see if it will pass that way. They currently have a yellow flag law, and I think that there's been a lot of push to change that in the state of Maine. I, you know, we've also seen some states introduce ERPO laws year after year and not pass them. I will say in terms of implementation, I think we are seeing states increasingly using these states that have adopted them. And I know that's something Lisa has worked really hard to get the data to better understand the uptick in numbers over time.
And if I could just add on the data, the follow-up to that question was about that statistic that I said there's been over 75,000 ERPOs. And the reason why that's a conservative estimate is that has just been me doing outreach to courts or to state bodies that collect data on their ERPO use and simply adding it up in a spreadsheet. So the time period is going to vary because the states have had their laws for different periods of time. So for California, they have great data and it's almost in real time. So I'm able to get all of the numbers of California's ERPO use. For some states, I might not have 2025 data. I might just have 2024 data. So I would say it goes back to the beginning of states implementing these orders to as recent as I am able to get the data, which is why it's a conservative estimate because some states I don't have anything for 2025. Some states I have the first 6 months of this year already. And so it really will depend. But I would say there's been at least 75,000 ERPOs issued across the country using that metric.
Thanks, Lisa. One question that was raised is, does the receiver of an ERPO have access to the information about who filed against them? And subsequently, has there been family members who are subsequently hesitant to reveal their identity in requesting an ERPO? Sort of what barriers does that pose?
I can take this one, Lisa.
Yeah,
So,
it's a great question.
it is a great question. So, yes, the respondent has the right to know who filed the ERPO against them under, due process protections, and they have the right to confront that person in court. And the respondent has the right to see and read what the petitioner, whether that's a family member or someone else, articulated as the risk factors that they saw in that case. So, yes, that has made some family members understandably hesitant to file for an ERPO against a loved one. In those situations, we're often seeing family or household members call on law enforcement or other eligible petitioners to be the one that files against the respondent. And I think where Lisa and I sit, that makes a lot of sense because we want to make sure that we're not doing anything to cause more harm. And if that family or household member is a part of their support system, we don't want to do anything that would fracture their support system. And so, making sure that they are supported is really important. And so it makes sense in a lot of cases for law enforcement to do the filing so that that family or household member can continue to be that support and not have any kind of adversarial relationship with the respondent.
Thank you for that answer, Spencer. And that actually sets up our couple of our next questions. First, thinking about sort of these, family members, do you know what kind of training is being provided to non-law enforcement professionals and also just everyday family members and schools who can bring about an application to make sure they understand the tool and how it can be used?
There's, to my knowledge, and if someone has a different answer, correct me in the Q&A, but there's no like uniform training body for these non-law enforcement professionals. And even for law enforcement and judges, we're not seeing, for the most part, any, routine cohesive training on ERPOs that's happening at a regular basis. We are seeing a lot of one-off trainings. We do webinars. We also bring in, so we work with a ton of law enforcement all over the country to do our training. So when we do a law enforcement training, Spencer and I will bring in law enforcement in various ERPO states to train with us. That's what we did last week when we did a behavioral threat assessment and management training with some law enforcement. And same thing with the judiciary. So next week, Spencer and I are speaking at a judicial conference with judges who have presided over ERPO cases. And so we reach those groups in those various ways. There are a lot of state entities like state sheriff's associations, state police associations that will do, one-off trainings that either we've been a part of or not. But for those non-law enforcement petitioners, I think it's really going to depend on the impetus of some local person on the ground who wants to make that type of training happen.
And so if you want that training, please feel free to reach out to us, and we will try to support that or connect you with the right folks to do that in your jurisdiction.
Thank you, guys. And speaking of law enforcement, we have a couple questions about our law enforcement partners. Have law enforcement officers that you've connected with reported any challenges in ensuring that firearms are being surrendered, while they're serving those ERPOs?
So a lot of the work is being done before they go to get the firearms that are being relinquished, and understanding, working with the petitioner or family or household members to understand what firearms the respondent has, where they're stored, looking at any purchase records that might be available in that jurisdiction or any other records that they have to understand what firearms the respondent possesses. And then I think knowing that information often helps law enforcement have conversations with the respondent to ensure that they're relinquishing all firearms. In some jurisdictions, ERPOs have a companion search warrant that's used to ensure relinquishment. But we're seeing a lot of really skilled law enforcement working to speak with the respondent, de-escalate the situation, and get voluntary compliance with the ERPO.
Do law enforcement officers face any personal challenges, for instance, anything like civil or legal when they're listed as a petitioner? Is there any backlash that they potentially face in this process?
One issue in that arena that we've seen is an issue when a law enforcement officer's name is on the petition as opposed to the agency, because if the petitioner doesn't show up to court, it can be dismissed. And so if you have a law enforcement officer who's petitioning for an ERPO and maybe the hearing is scheduled on a day when it's their day off, or they're otherwise unable to get there, that case could be dismissed. So one of the recommendations, I believe we have this in one of our reports, or at least have talked about this before, is that the petitioner be the agency. I also personally don't think it's necessary for that individual's officer's name to have to be on that petition. Some states I think do require that, but if it could be the XY city, I don't want to call any city out, but police department's name on the petition instead of Lisa Geller as the petitioner, I think that would be a best practice. But I don't know that fully answered that question, but at least is one issue we've heard from law enforcement.
One question I was thinking about, obviously here in New York State, our ERPO law evolved, so to speak, after the 2022 shooting in Buffalo. And I'm wondering, obviously we know that law enforcement is typically the petitioner, right, in a lot of cases. But do you guys see, or what are some of the benefits that you guys see of letting other groups serve as petitioners, like family members or even school personnel?
I think that the more opportunities we have as a society to intervene when we see that someone is behaving in a reckless way and exhibiting these extreme risk factors, the better. I know in some communities, folks might not want to call law enforcement or might not feel safe doing so. And so having other people eligible to petition can help bridge those gaps when that's not a viable remedy in those communities. And so I think it can be helpful, but like Lisa said earlier, the overwhelming number of petitioners that we're seeing are law enforcement across most of the country.
Thank you so much for that, Spencer. And we're going to go to our last question here. We unfortunately did not have time to get to all of those. So if we did not get to your question, please certainly feel free to reach out to Spencer and Lisa. Their email addresses, as well as mine, are listed in the chat. Would you guys be able to speak to the role of healthcare providers in the ERPO process? Is there any data around how often they're being used in that capacity?
Sure. So a lot of healthcare providers, even in the states where they're eligible, there's 7 states, are not using this tool. And I think to date, there's been 3 or 4, potentially more, papers examining some of the barriers that healthcare providers are facing. So to the person who asked that question, feel free to reach out to me, or you might be able to find it just by Googling healthcare providers or clinician barriers to ERPOs. So there are some states that are using it. I think more often a clinician might be working with a concerned family member or with law enforcement in some instances to get them to file, because some of the barriers that clinicians face is time going to court. Time spent going to court means time that they're not spending with their patients. And additionally, some concerns about HIPAA, although I would direct folks to HHS guidance on HIPAA and extreme risk protection orders to see how clinicians can, work with HIPAA laws and while, getting an ERPO in cases where it might help their patient. But I think that until some of those barriers are addressed, it's going to be, we're not going to expect to see a lot of healthcare providers using ERPOs. But again, like Spencer said, we think that other groups should have the ability to access this tool should they want to use it. But what we're seeing is it's mostly law enforcement filing.
Thank you for that, Lisa. And thank you again, both Lisa and Spencer, for sharing all of this information with us today. I know I personally am going to take away a lot from this conversation, especially about how I think of prevention moving forward. And thank you everyone on this call for joining us today. As a reminder, we will share out the playback of this webinar soon. And please feel free to share this with anyone that you think might be interested in today's conversation. Thank you so much, everyone, and we hope you have a great rest of your day.